Good afternoon, friends, and welcome to the EduSat Network. Our topic of discussion today is democracy and constitutionalism in Indian and comparative perspectives. This is part one of this lecture. Another shall be following tomorrow, friends. And for this lecture, we have this in our studio, Dr. M.P. Singh, retired professor of political science, University of Delhi. He has a teaching experience of more than 4 decades, and Professor Singh is currently an honorary senior fellow and director of research at the Center for Multi-Level Federalism Institute of Social Sciences in New Delhi. And Professor Singh was awarded the prestigious Paul Appleby Award 2014 for distinguished service to the IIPA and to the subject of public administration by IIPA New Delhi. And with this introduction, I would like to welcome sir to our studio and also request him to begin our today's lecture. Thank you so much, sir, for coming.
Thank you, Roshi. The topic for today's lecture is already announced. This relationship between democracy and constitutionalism is at the heart of democratic federal governance, democratic governance in general. And this relationship we will try to explicate and point out the tensions between the two, as well as reconciliations between the two. The tension arises because democracy is defined most commonly as the rule by the majority, and constitutionalism is defined as the government limited by constitution or rule of law. So the two terms appear to be contradictory, at least to some extent. Despite some overlap between the two, there is some tension between the two. Now, because, as I said, there are people who point out that how can tyranny of the majority and the rule of law can go together. Now, as I said, this supposed contradiction is more apparent than real, and it can be reconciled. Now, how this reconciliation is possible? What are the constitutional mechanisms through which this can be accomplished? Now, I will begin with a sketch of evolution of democracy and later constitutionalism. Earliest historical traces of democracy were found in ancient India in the Rigvedic Sabhas and Samitis around the 1000 BC, and in some republican states such as Vaishali in ancient India around 6th and 5th centuries BC. Democracy was also practiced in the Greek city-states, most notably in Athens in the 6th and 5th centuries BC, around the same time as the earliest traces of democracy were visible in India. Now, decline and demise of democratic institutions followed both in ancient India as well as in Greece. In India, republics were superseded by monarchies with the rise of Nandas in Magadh, and the 16 Mahajanapadas that are mentioned in a Buddhist text, some republican, some monarchies. Subsequently, monarchy overtook the republican states. And in ancient Greek also, democracy became unpopular. Democracy became a subject of, skepticism because it came to be equated with mobocracy or crowd rule, and it was even the great philosopher Plato regarded it as a corrupt form of government. Aristotle had a more, comparative attitude towards democracy, but even in his classification, democracy does not appear to be a favored regime or theoretically justifiable regime. Polity was the form of government in contrast to democracy that Aristotle supported. So, democracy in its ancient form, both in India and Greece, was superseded or overtaken by undemocratic forms of government. Now, later on in the West, democracy did surface, in Roman Republic and Italian city-states between the 12th and the 16th centuries. The ancient Roman Republic and the Italian city-states experienced democratic practice later on through the 12th and the 16th centuries. Democracy in India, after its eclipse in ancient times, does not appear, in later ancient Indian history or in medieval Indian history. In fact, only the other day, and a political economist, a great political economist of India, asked me whether there is any evidence of democracy in medieval Indian history. I thought about it, and he in fact said that in the Western countries during the long Middle Age, during the medieval period, feudal institutions or feudal states did have some proto-democratic institutions. The lords and commons and the three estates in the ancient regime, pre-revolutionary France. He asked me whether such institutions are evident in medieval Indian history. I could not think of any. Then he asked me what were the reasons. Probably the reasons could be, of course it's a subject on which historians will have a definitive say, but one could argue that perhaps it was the inegalitarian inequalities inherent in the Varna system, the caste system, hierarchical caste system, and the cumulative inequalities of the Indian societies, including the constant warfare among the regional states of India, the constant war among competing kingdoms, and subsequently foreign aggression did not allow the kind of democratic, proto-democratic institutions that one finds in Western medieval history during the phase of feudalism. Now, democracy, as we know today, representative democracy, it made its appearance. Earlier forms of democracy that we mentioned were proto-democratic institutions. They were not democratic institutions in the present sense of the term. And the present sense of the term of democracy is that it's a representative democratic system in which the elected representatives of the state, by popular election, popular choice, they are elected. So representative democracy as a form, including some direct democratic experiments, appeared, at the end of the 18th century, after the American Revolution, 1775, and after the French Revolution, 1789. The two revolutions the American Revolution 1775, the American War of Independence, and the French Revolution 1789, they produced the form of modern democracy that we are familiar with today. Interestingly, there is a contrast drawn between the American Revolution and the French Revolution, and this contrast is drawn by Alexis de Tocqueville, a French aristocrat who visited the United States of America during the 1830s, around the same time as Raja Ram Mohan Roy flourished in India. De Tocqueville, a French aristocrat, visited the United States of America. Now, if you read his two-volume classic, Democracy in America, this French aristocrat, who was not a feudal person, who was a modernist person, a modern person, but he appears to be tortured by the excesses of the French Revolution, the extreme violence and excesses of the French Revolution, the authoritarian excesses, authoritarian excesses in the French Revolution tortured his soul. And when he visited the post-revolutionary America after the War of Independence, he found a kind of solace that provided some satisfaction to him. America had a moderate revolution. And the American Revolution resulted in the establishment of a democratic federal state that still continues. The same constitution continues to this day. In case of the French Revolution, the revolution initially provided democratic outburst, but it was overtaken by war and Napoleonic dictatorship. So democracy was submerged into dictatorial takeover of the revolutionary possibilities or democratic possibilities of the state. And it was much later that France recovered its democracy from the Bonapartist, Napoleonic and Bonapartist authoritarian intervention that emerged after the revolution there. Now, modern democracy appeared in India towards the end of the 19th and early 20th century, and it continues even today. That means that democracy in India appeared in its earlier forms, in its earlier traces, beginnings of limited democracy, beginnings of limited democratic elections, limited democratic participation, through nomination and subsequently through election. All these practices appeared in India, modern India, during the British Raj, beginning with the East India Company and subsequently after the 1857 rebellion, the British Crown took over directly the governance of India, the government of India, and these earliest traces of modern democratic institutions made their beginning in India around that time. Now, arguably, we have three major versions of modern democratic theory today. In political theory, in theories of comparative politics, we have three major versions of modern democratic theory today. The first is the classical social contract theory. The classical social contract theory was produced by Hobbes in the 17th century, Locke in the 17th century, Rousseau in the 18th century. Now, this preliminary modern democratic theorization primarily focused on voluntarism and popular will as signified by a contractual consent to the setting up of a civil society and the state. The social contract theorists, their contribution to democratic thought or democratic theory is that they tried to introduce in post-feudal Europe, in the earlier days of modernity in Europe, post-feudal Europe, they formulated the social contract theory, and through the social contract, people entered into a contract, and through their consent, through their willing acceptance, civil society and sovereign government or democratic government or authoritarian government, that is a matter of debate. We don't have time to go into them. Hobbes, produced an authoritarian state, that was produced after the Hobbesian contract. Locke produced a theory of democratic civil society and state, and Rousseau produced a theory which rationalized popular sovereignty or direct democracy. Now, the second model of democratic theory is aggregative or elitist model of democracy. Now, this model focuses on the procedure of aggregating the wills, popular wills for decision making and government, how popular will is aggregated into a proper decision making process and mechanism, and but this model of democracy is also called elitist model of democracy, because these theorists mainly argue that democracy is a mechanism of electing the elite. Democracy doesn't mean direct rule of the people, government by the people. Democracy essentially means an elitist phenomenon, an elitist mechanism of government in which the role of the people is limited to electing their representatives. Now, this elitist model of democracy finds its expression in the writings of Joseph Schumpeter, Giovanni Sartori, Schumpeter, the German-American political economist, Giovanni Sartori, the Italian-American political theorist, and the Italian political theorist Norberto Bobbio. Now, they argue that in modern large societies, democracy has come to minimally mean a set of rules to elect representatives, either through majority system of representation or plurality system of representation or proportional system of representation. So democracy basically, by and large, means a mechanism of deciding who governs, not the people, but representatives of the people. Now, the third model of democracy is called pluralist, or more recently it has come to be called deliberative model of democracy. The pluralist model of democracy, or more recently deliberative model of democracy. Now, this theory or this model finds its articulate presentation in writings of John Stuart Mill, the British liberal democratic theorist, Jeremy Bentham, the British utilitarian, Robert A. Dahl, the American democratic theorist, John Rawls, the American theorist, liberal democratic theorist, whose theory of justice has become universally a major contribution, perhaps the most important contribution in opinion of some, to theory of justice, his theory of justice is considered to be a significant major contribution to liberal democratic theory. This version of democracy is also found in the writings of the contemporary spokesman of the Frankfurt School, the critical theory school in Germany. I am referring to Jürgen Habermas, Amartya Sen, and Irish Marian Young. Also, Amartya Sen, the Indian, Nobel laureate in economics, who is an Indian citizen, but has taught in the US and is presently in the United Kingdom. And Irish Marian Young is also, a contributor to this version of democratic theory. Now, this version of democratic theory emphasizes the procedural aspects of democracy that make it a more noble way of governance, a more noble form of governance, because this model emphasizes that democracy has to be made more and more representative, more and more participative. Popular participation should be a part of a better democratic state. This model also emphasizes the epistemological possibility of formulation of better public policy through popular participation and through deep deliberation, a more defensible, more justifiable, a more viable and public policy that is more in public interest. All these possibilities are made achievable through democracy. These theorists also argue that democracy promotes justice. Democracy promotes justice. A very well-known, well-cited argument of Amartya Sen is that famine which results in large-scale death does not occur in democracy. Famines have devastated only undemocratic states. If the system is democratic, famine doesn't occur at least in the same devastating form as it has happened repeatedly in undemocratic countries. These theorists also argue that democracy promotes not only justice but liberty and equality among the people. There is progressive increase in justice. There is progressive increase in pursuit and possibility of achieving justice, liberty, and equality in a society, in a democratic system. They also argue that democracy values intrinsic worth of individuals. Democracy makes possible moral citizenship. Moral virtues of citizens can be cultivated through democratic institutions. So these are the three models of contemporary models of democracy we find in contemporary political theory. Now there is in fact another model of democracy which has become which has appeared more recently after the collapse of communism, in Soviet Union and Eastern Europe, and after incremental adoption of capitalist principles within a Leninist state, within a Marxist or communist state in China. after these events, a new brand of neoliberal theory has emerged, and neoliberal model of democracy, which earlier found its expression in Buchanan and Tulloch, and subsequently, this model has been made popular by the World Bank and IMF and Bretton Woods institutions, capitalist institutions produced after the Second World War. Now, they argue, neoliberals argue, that elites in democracy, political elites in democracy, generally tend to expand the powers of the government and bureaucracy. They tend to give more and more power to democracy, to government and bureaucracy, and it results into the interventionist state, the big government, and such states and such governments are inefficient and increasingly more and more inefficient, increasingly more and more a burden on the people, and therefore the neoliberal model of democracy advocates transfer of many of the functions of the big state or the big government to the market and to the civil society, and they want to limit the state to the role of the night watchman. The state's function should be limited to protection of liberties and property. That's what they believe. Now, the foregoing models of democracy are not entirely exclusive. I mean that one model does not entirely exclude the other model. There is some degree of overlap between the various models, but then in terms of emphasis, there are distinct points that differentiate one model from the other. Now, in successive stages of the emergence of these democratic theories, we find how the most popular definition of democracy has become refined gradually. The most popular definition of democracy has come to us, which almost any undergraduate student will immediately tell you. It's a quotation from a former American president, a 19th century American president, Abraham Lincoln. Lincoln, in his famous Gettysburg Address, defined democracy as a government of the people, by the people, and for the people. But the models of democracy that we just discussed above demonstrate how each of these three elements of this definition is not enough, is found to be wanting on a scrutiny. If you scrutinize, you will find that all the three attributions, democracy, a government of the people, by the people, and for the people, on close scrutiny can be found too rhetorical or too optimistic, and it doesn't take into account the complexities of democratic governance. Now, constitutionalism, the second major conceptual construct that is part of our discussion today, is constitutionalism. Constitutionalism, on theory of constitutionalism, a well-known American political scientist, American political theorist, Charles McIlvaine wrote a justly famous book, Constitutionalism, Ancient and Modern. The book was published in 1947, and it is still a classic on theory of constitutionalism. Charles McIlvaine delineates two conceptions of constitution. Since he is an American, he is sensitive to America's contribution to constitutionalism or constitutional theory, since America happens to be the first modern state with a written constitution. American Constitution is the first written constitution of modern times. Now, Americans are very proud of it, and Americans generally try to, explicate this American phenomenon and formulate political theories relating to constitutionalism, although it would be wrong to say that the idea of constitutionalism is entirely an American contribution. There are British legal theorists who have argued in similar vein earlier than American theorists who have formulated ideas or concepts of constitutionalism. Like, for instance, the British legal expert Sir Edward Coke. If you read Edward Coke's writings, who was a British judge, you find that the British were equally conscious of the fact that constitutionalism should be one of the features of a good democracy. In any case, McIlvaine delineates the new conception, definitions or concepts of constitution. McIlvaine says that constitution means a conscious formulation by a people of its fundamental law. Now, this describes the American experience. Americans formulated or drafted the first written constitution, and you find there a conscious attempt to formulate, draft and enforce a constitution for the governance of the country. The second meaning of constitution, which was the earlier meaning, is recognized by McIlvaine, and the classical or the traditional view of constitution is that a constitution is the word constitution refers to the substantive principles to be deduced from the nation's actual institutions and their development. Now, if you think about this definition, your attention will go to the United Kingdom. United Kingdom doesn't have a written constitution, and what the British call their constitution has evolved from their actual historical experience, how democracy has gradually evolved in practice. There was a war between the forces of the crown and the forces of the parliament, and in this war between the royalists and the parliamentarians won and established, and an act of parliament was enacted which encapsulated the principle of parliamentary sovereignty, and the sovereignty of the crown was transferred to the sovereignty of the parliament. The sovereign power of the crown was transferred to the parliament. So, British constitution thus is a product of actual historical evolution, and there is no written document except for laws of the parliament. Laws of the parliament are not constitutions. Laws of the parliament are there today, and the parliament can amend it mostly by simple majority, any act of parliament, and therefore there is a distinction between between a constitution and a law of parliament, and the Americans capitalized on this distinction, and they created a constitution which cannot be easily amended. A special process of amendment, consensual process of amendment, a difficult process of amendment is required to amend the constitution. So, these are the two senses of constitution that McIlvaine, the American and the British, that McIlvaine explicated in his book. And and then constitutionalism has come to mean a government limited by the constitution or laws of a nation. So you notice that the two terms that we have been discussing, democracy and constitutionalism, have different thrusts. Democracy is broadly or basically majoritarianism, and reflected through parliamentary resolution or parliamentary enactment, whereas constitutionalism limits a constitution, a written constitution limits the powers of all organs of the government, and all organs of the government are limited by a written constitution, and that's why it is said that constitutionalism basically means limited government, whereas parliamentarism in the classical sense of the term is not a limited government in the sense that the will of the parliament is supreme and there is no limits on will of the parliament. Although if you go into the details, if you go into the actual practices, if you go into the scholarly literature, parliamentary sovereignty must be understood in a more complicated and a complex way. But we are talking here of the basic thrust, what happens when the argument is finally clinched, if it comes to a conflict. We are referring to that situation. Now, summing up our discussion so far, we may say that a hiatus is discernible between democracy reduced to the majoritarian principle in ultimate operational form, and hence in a way unlimited in the sense of popular or parliamentary sovereignty on the one hand, and constitutionalism in the sense of limited powers of all organs of government or state on the other. If this gulf is this gulf unbridgeable, or is a reconciliation between the two possible? I believe in the feasibility of a reconciliation, as I have already made it clear right at the outset. Now, whether we live under a democracy or tyranny, absolute power of the state is limited by the theories of rights and duties. These rights and duties may be self-imposed or externally enforced. Even in the state of nature, Hobbes recognized natural rights. Of course, theorists like Locke and Rousseau recognize natural rights all right, but Hobbes is who supports or whose social contract theory results in the establishment of an absolute sovereign whose powers are not limited, because once the people sign a contract or enter into a contract with the sovereign, they surrender all their rights to the state. But even Hobbes, who subscribes to this view of social contract, even he recognizes that even in the state of nature, which was a state of war, natural rights were existent, and even after the social contract, that gives all powers to the sovereign, all powers to the state, natural rights of the people are retained. And the most important natural right that Hobbes mentions is the right to self-preservation, the right to life. Now, in political as well as legal theory, we have different kinds of theories of rights. Natural rights are those rights which are never compromised. We enjoy those rights. Well, they are another term for human rights. They are enjoyed by they exist in nature and no state can abolish them. Moral rights are different from legal rights because moral rights are subject to our good sense, our virtues, whereas legal rights are enforceable by the state. Common law rights, rights that exist in tradition, not in positive law, but even before a positive law is made by the parliament, we have certain common law rights based on custom and tradition. And fundamental rights or human rights which are entrenched in the Constitution. I am referring to all these rights to argue that democracy and constitutionalism cannot be completely dissected or cannot be completely separated, and even a democratic state, even a democratic state that is not a constitutional state, according to some theorists, rights are never extinguished, and therefore it would be wrong to say that democracy gives right to the state to abolish power to the state to abolish all rights. It would be wrong to say. And in this complicated argument, if we make the argument more complex, we see a light, we see a possibility of reconciliation between democracy and constitutionalism. Now, in political theory, John Rawls' theory of justice, to which I made a reference earlier, succinctly combines both democracy and constitutionalism. I said that John Rawls is regarded as the most significant liberal democratic theorist today, and his celebrated book, A Theory of Justice, if you read that book, you find that in his theory, in Rawls's theory of justice, there is evident reconciliation between democracy and constitutionalism. Justice is declared to be the first virtue by John Rawls, and he says that justice must underlie the basic structure of any society, the basic structure of any political system, the basic structure of any social system. So the basic structure, what Rawls calls the basic structure of political, social and economic institutions of a society, must be based on justice. And his 2.5 principles of justice are liberty for all, equality of opportunity for all, and differential principle for the least advantaged. Rawls believes in liberty and equality for all, and the only inequality that he allows is for the least advantaged sections of the population. The least advantaged sections of the population are the only segment of population for whom any departure from equality can be made. Now, Rawls does not rule out the possibility of right to rebellion in his concept of democracy. His concept of democracy, his concept of a state, liberal democratic state based on justice, allows the possibility of rebellion, civil disobedience. Civil disobedience is not ruled out by Rawls. Now, it seems to me that Rawls' theory shows how democracy and constitutionalism can be combined in the same state. In fact, to tell you frankly, while reading Rawls, I am always reminded of the Indian Constitution. To me, it appears as if Rawls' theory is distilled from the Indian experience, the Indian Constitution. Differential principle or the reservation principle only for the most least disadvantaged sections of the population. Otherwise, liberty and equality, Indian Constitution, the fundamental rights chapter and the directive principles of a state chapter in the Constitution, provides for liberty and equality for all, and reservation only for the most disadvantaged sections of the population, the backward classes. So, it appears, and Rawls's book was published in 1971, whereas the Indian Constitution was drafted in 1946-49. And therefore, whenever I read Rawls, I'm always reminded of the Indian Constitution. So my argument is that there is a possibility of reconciliation between democracy and constitutionalism. And the final comment on this point I would make is to refer to Albert V. Dicey, the British constitutional expert who wrote a book called the law of the Constitution. His classic that was published in 1885 is the most elegant enunciation of British constitutionalism. And British constitutionalism is very difficult to decipher in the sense that there is no written constitution in the UK. It's a combination of customs and traditions, conventions, common law, customs and traditions, constitutional conventions, some parliamentary acts, but no single constitutional document coherently written. Now, Dicey deciphered three basic principles out of this jungle, legal jungle. And what are the three principles that Dicey enunciated or deciphered, characteristic of British constitutionalism? Number one, parliamentary sovereignty. Number two, rule of law. Number three, constitutional conventions or customs, constitutional conventions or traditions that are habitually obeyed. Now, parliamentary sovereignty is at the top because three values in Dicey are hierarchical. So, parliamentary sovereignty is given the first position, but it has to be harmoniously reconstructed within the framework of rule of law and conventions of the Constitution. So ultimately what we find that the transfer of absolute power of the Crown transferred to the Parliament as its absolute power doesn't mean that the Parliament can do anything, although there are British jurists who have said the Parliament can make anything, make a man a woman and woman a man. The Parliament can order the boiling of Mr. X in hot water, and there would be no judicial recourse, recourse or remedy, because, as you know, the acts of Parliament in the United Kingdom are not subject to judicial review, but in practice, the liberties and rights of the British people have never been trampled upon by the Parliament. It must be said to the strength of British democracy and a strength of the common law, a strength of the civic culture of the country, that parliamentary sovereignty doesn't mean tyranny of the majority, and in practice parliamentary sovereignty or the absolute power of the Parliament has been reconciled with rule of law, what we are calling constitutionalism. I suppose there are 6 to 7 minutes left in which we can take some questions.
Thank you so much, sir, for this presentation of yours. And with respect to that, sir, as you suggested, we would be having a bit of a discussion. I will be asking you a few questions, sir. Then, as we discussed democracy and constitutionalism, how is it the ideas unfolding in the Indian context?
In the Indian context, the idea is unfolding in a way that is very interesting. After the Constitution was enunciated, the principle of parliamentary sovereignty, because we are part of the British tradition, British legal tradition we have known in the past, and even though we modified it, the principle of parliamentary supremacy, which finds limited acceptance in Commonwealth countries like Canada and Australia, also found its expression in India. In Canada and Australia, judicial review is possible. Judicial review of laws of Parliament and executive orders are allowed, but the behavior of judges in Canada and Australia is not marked by activism. Canadian judicial behavior is marked by judicial restraint. Australian judicial behavior is marked by legalism. India also began in the same way, and the early tendency of the court, Supreme Court, to declare several acts of the Nehru government and several acts of some state governments unconstitutional. When it happened, it appeared very clear that the courts are inclined to be activist, but Nehru and his law minister Ambedkar introduced the first amendment to the Constitution and created a schedule. The 9th schedule was added to the Constitution, and parliamentary sovereignty or primacy of the Parliament, it would be wrong to use the term parliamentary sovereignty in the Indian context, because parliamentary sovereignty is circumscribed by fundamental rights in India. There are no fundamental rights in UK. Parliamentary sovereignty is subscribed in the Indian context by federal division of powers between the Parliament and the state legislatures, and in the UK there is no federalism. So parliamentary sovereignty can be legally tenable, constitutionally tenable in the UK, but not in the Indian context. But even in India, we find that the first amendment tried to establish some Indian version of parliamentary sovereignty, but subsequently by 1973, the Supreme Court of India, in the Keswananda Bharati versus the state of Kerala, rejected the total validity of the 9th schedule, and from that date, from the date of judgment of Keswananda Bharati case, the acts put in the 9th schedule have become subject to judicial review. Putting any act of the Parliament or state legislature within the state legislatures within the 9th schedule meant that they would be immune from judicial review. The courts cannot scrutinize them. By 1973, the courts rejected the absolute primacy of the 9th schedule, and the Keshavananda Bharati judgment also propounded the theory of unamendability of the basic structure of the Constitution. Now, basic structure of the Constitution cannot be amended by the Parliament, so the courts have ruled, and it has become part of Indian constitutional law by now, and therefore we find that even though the Indian democracy started acting in a way that parliamentary sovereignty was hedged in the same limited way, not in the British way, but in the same limited way as in Canada and Australia, that even that limited hedging of parliamentary sovereignty, typical of Canada and Australia, in India is now unacceptable, and it has come to be rejected under the theory of the basic structure of the Constitution. So the power of the Parliament to amend the Constitution has now become a power shared between the Parliament and the Supreme Constitutional Courts, that means Supreme Court and High Courts, and therefore by now democracy and constitutionalism in the Indian context also have come to be reconciled through a complex process of judicial discourse developing along the side of discourse of parliamentary supremacy in a limited way. I am always adding the term parliamentary supremacy in a limited way in the Indian context, because the Indian constitution is very different from the British constitution.
Right. Thank you so much, sir, for addressing that query of ours, and of course the students would also be able to pick up bits and pieces of their doubts from that. So with that, I would like to first of all thank sir for being here.
Thank you
so much, sir. And also tell our viewers that tomorrow shall be the second part of our lecture on this topic named Democracy and Constitutionalism in Indian and Comparative Perspective. So I hope you stay tuned in for that, and that will be very useful. So thank you very much for watching. Have a wonderful day ahead.